All right. Good afternoon, everyone. Thank you so much for joining us. Thanks again for your patience, but we are very excited for the turnout that we have for our webinar today with Wayne Zell. So I will do a brief intro of Wayne, and then we will get right into the material. For those of you I haven't met, I am Ann McCabe, the CEO and a partner here at Curo Private Wealth, and I'm joined by Atrisa, who is our COO as well as a partner. She's unfortunately off video right now, but with us. So Wayne, thank you again for agreeing to do this webinar. As we can see by the number of attendees, it was a very popular topic. So we will let you get into your material because that is why everybody is here today. But Wayne is the managing member and CEO of Zell Law here in our backyard in Northern Virginia in Reston. And he's an active speaker, award-winning author, and has been advising clients for over 30 years on areas such as business succession, business exits, and estate planning, which of course is our topic today. He wrote an awesome book called Your Multi-Million Dollar Exit, which helps entrepreneurs prepare and successfully exit their companies. And he also hosts a series of podcasts, an educational series called Blueprint for Wealth, where he interviews entrepreneurs. And he also is an adjunct professor at George Mason University in the financial planning and wealth management concentration in the School of Business, something near and dear to my heart. And I've personally known Wayne for, I don't know, Wayne,
A long
over,
time.
yeah, I was gonna say over 10 years, probably creeping
At
up on
least.
20.
Yeah.
So yeah. So just really grateful for your time and for your sharing. And I will make you host here and turn it over to you. But thank you everyone for joining. And again, Wayne, thank you so much for the awesome material that I know you are about to go through.
Awesome. Thank you so much. Thanks for having me.
Yeah. Okay. So
And
you
tell
should
me
be
when you
host now.
shift. Okay, so I can put my,
There you go.
there I am. Um, what I'll do is I'll share my screen with everybody so you can see the presentation I'm about to give. And here it is. And we'll just do a little quick slideshow. Start it. Okay, so this is a presentation I've given many, many, many times. I've done it for Blueprint for Wealth, my podcast, and I've also given it in sessions to financial planners and their clients. And so this is sort of a summary. And I noticed that a couple of you are already clients of ours, and thank you for tuning in today. And your questions that you asked, and we'll get to your questions. And this may answer some of your questions as we're going along, but my intent is to try to educate you as much as possible. So we're going to just talk about basic estate planning real quickly. I'm not going to go into a lot of detail on this, but I am going to try to focus on what's important when you do your estate planning. And these are the sort of my values or my guidelines as to what an estate plan should consist of. It allows you to control your property while you're alive and well. It allows you to plan for yourself and your loved ones and make sure that you give what you have to whom you want, the way you want, when you want to. So you're in control until you no longer are able to be in control. But importantly, you want to leave a legacy for your family. Your estate consists of a variety of assets, obviously money, life insurance, your home, your personal property, but it also consists of your family and the legacy you want to leave to them and your values. And more, we're actually incorporating those into the estate planning documents, either as an attachment or as part of the estate planning documents. The goals should be to care for yourself, first of all. Always take care of yourself first. Take care of your spouse if you have a spouse or a partner. Take care of your adult and your minor kids. Pass on these values and your ideals to your heirs if you want. You don't have to, but we often do that, and it's become more of a focus in our estate planning practice. Saving money for yourself to make sure, and that's why Anne and Atricia are so important to you, because they are part of a team that I participate on. The financial planner is absolutely critical to making sure you've saved enough money to last your lifetime. And that may be till you're 80, till you're 90, till you're 100, till you're 120. And as the longevity increases over time, you want to make sure you've planned for that, most importantly. And then keeping control over what you have worked so hard to accumulate during your lifetime. The common planning techniques are do nothing. You can own property in joint name. You can designate a beneficiary. We're going to talk about all these things. Sign a will. Have a revocable living trust, which is important in my practice, and funding it, and then having powers of attorney and advance directives to complement the estate plan. Doing nothing is not the same as some of these other things. And so doing nothing is not going to accomplish anything. It's no plan. It guarantees that your assets are going to have to go through the court system known as probate, and it gives control over what happens to your assets to the state via the intestacy laws. So you lose control if you do nothing, and that's not good planning. If you die without a will or a trust, then a court is going to select who controls your assets, and state law will dictate who it goes to and how it goes to them. That's not good planning. A will, at least, in your will, you can name who controls what and who gets what when they get it. So that's what this table is meant to include. And we'll be able to distribute these slides to you later on if you want to get copies of them. Owning property jointly is very common. Everybody does it, right? So married couples have houses or bank accounts in joint name, or tenants by entireties for married couples. Oftentimes, parents will put their kids on a joint account to make it more convenient for the child to get access to the account so that they can help take care of the parent when the parent can't take care of themselves. But that leaves a huge gap in planning, and I'll tell you why in a second. Also, anyone can be a joint owner. I hear some typing, so somebody may want to be on mute if you're not already on mute. Jointly held property has its own rules. What are the rules? It's a game of survivorship. Whoever's last to survive wins. And that means they get 100% ownership of whatever was in joint name. And then they get to decide what happens with the property, not you. So a will does not control joint property. A trust does not control joint property, much to the chagrin of many people I've come in contact with over the years. So having assets held jointly overrides a will or overrides a trust, and it's the asset passes by operation of law. The benefit of joint ownership, obviously, is that it automatically passes to the joint owner. So you don't have to go through probate, at least on the death of the first owner. But on the death of the survivor, you will have to go through probate. And that's one of the problems with joint tenancy. It can create unintended heirs. What do I mean by that? Let's say I have an asset that I put in joint name with my spouse, and I pass away. She inherits the asset by operation of law. Now, she can do whatever the heck she wants, even though we had an estate plan that said, I want the assets to go to my kids. So she can then get remarried and give all the assets away to the new spouse, or give it all away to charity or the new spouse's family. And I've seen it happen dozens of times. This is why jointly owned property is not the best planning technique. And it does not totally avoid probate, meaning that on the death of the survivor, unless they've put their assets into a revocable trust, it's going to go through probate at the second death. Why do that? Here's another issue. I want to put my kid on the title to my condo or on my real estate. The minute you do that, you've made a gift of half of the property, and it has to be reported to the IRS on Form 709. And you have to use some of your lifetime exemption that you may not have intended to use before you intended to use it. And so that's one unintended consequence. You put your child on a joint bank account, the minute they withdraw the asset from the joint bank account, it's treated as a gift from you to them. Same consequence. So there's really no planning that you can do with joint property other than to avoid probate on the first spouse. Another issue is I've got assets that require a beneficiary designation. So joint property is separate from this. This applies to 401k assets, deferred compensation, life insurance. It can apply to bank accounts and investment accounts, IRAs. By naming a beneficiary, just like joint ownership, It overrides whatever you've put in your will, unless you've put in your will that the beneficiary is your trust, and then the asset will pass through the trust to or for the benefit of the beneficiary in the trust. So you have to be very careful about beneficiary designations. Let me give you an example. I name my spouse, but my spouse is predeceased. I name my child as a contingent beneficiary. My child is deceased. It goes through probate. But let's say I name my child as a contingent beneficiary on my 401k, my spouse is gone. And I said per stirpes, meaning that it goes to their kids. Well, if my grandkids are minors or under any kind of disability, it's still going to have to go through living probate, known as conservatorship in Virginia. So we don't want that. We want to be careful on how we designate these beneficiaries on all of these types of assets. It's very tricky. So these are the problems. It doesn't protect your spouse. I name my spouse as the beneficiary. Now she inherits a $5 million IRA. She decides, based on her liaison with a new spouse, that she wants to break the IRA and give it to the new spouse. There's no protection for the kids, and there may not be any protection for the spouse if they don't know how to manage the money or they're uncomfortable in managing the money. It can lead to unintended beneficiaries again. So again, there's no control after you've named the beneficiary. And so, some of you will say, I don't care. I trust my kid to do the right thing. What happens if something happens to your kid? I'll give you an example. My mom passed away 3 years ago and I was her trustee. My sister predeceased her by 3 years. She died 6 years ago. If we hadn't done the right stuff with my mom's planning, we would have had to go through conservatorships for her grandchildren. That wouldn't have worked out very well. So again, you want to think about all the eventualities, and that's what estate planning is all about. You should have a will. The will doesn't always cross state lines easily, and it, of course, doesn't become effective until you die. It does not protect against probate, and it may not protect your children, although you can build a will very comprehensively to protect your kids or your spouse. It's just that it doesn't avoid probate when assets pass under a will. And I'll explain why probate is bad. If you sign a will only, it not only guarantees probate going through court, but it also increases the cost. It's publicly available for inspection. I can look at every probate inventory and accounting that's been filed since 1976 in Virginia just by going online. And you can go down to the courthouse and see it. And that's what creditors do after somebody dies. So you can have multiple probates. Let's say I own a house in Reston and I own a house in Dewey Beach, Delaware. If you only have a will, the asset might pass to who you want it to, but you're going to have to go through multiple probates, one in Virginia and one in Delaware, to pass the property under an ancillary probate. And it takes time and it costs money. Wills are more easily challenged by heirs, so they can contest a will more easily than a trust. And again, it doesn't control assets that pass jointly or through beneficiary designations. There's two types of probate: living probate and death probate. Living probate is also known in Virginia as conservatorship, and it applies to people who are disabled or incapacitated, or minors, children under the age of 18. So if you left an asset to a grandchild because the parent predeceased, or you wanted to set aside assets for a minor child and you don't do it through a trust, it's going to be subject to conservatorship, meaning that accountings will have to be filed with the court every year until the child reaches age 18. And then at age 18, they acquire ownership of the asset. Death probate, same thing. It's controlled by the court and you have to pay the court. You also have to pay a probate tax in Virginia. So probate, death probate encompasses all this stuff. You've got to notify creditors. You may have to have a debts and demands hearing. You have inventories that have to be filed. Appraisals have to be made of the assets, and accountings have to be filed. And it takes a long time to go through probate successfully because the commissioner of accounts in every county in Virginia has the right to question anything that you submit, and they charge you for that privilege. So it's costly. Conservatorship is living probate. It applies to people who are disabled or minors. Again, it's expensive and unnecessary and all subject to public view. So we want to avoid probate for two reasons: the delays and the costs, the unnecessary costs. It can run up to 3 to 5% of assets that pass through probate, and it's not necessary to do that. Now, you always have to get appraisals, even if you have trusts, depending on your tax situation. But if you have even a small estate, you still may have to get appraisals to get through the court system. I use revocable trusts for all of our clients. There's two kinds. I'll call one a bare bones trust, that there's no funding, there's no assets being put into the trust. And there are a lot of practitioners who charge a couple grand to do bare bones trusts, estate plans around the area. You don't get anything when you do a bare bones trust. A bare bones trust means that there is nothing in the trust when you die, which means that everything still has to go through probate. The better alternative is to have a fully funded trust with all the ancillary estate planning documents that take care of you during your life as well as after you're gone. So again, a bare bones trust might include something you find on LegalZoom or Trust and Estate or TrustMaker. There are various software programs out there. And as artificial intelligence gets more intelligent, it's going to become more prevalent to see these software programs producing better and better documents. No question. But you're not lawyers and you're not experienced in trust and estate planning, and you don't know tax law. So you're going to need somebody, whether it's us or somebody else, to come in and help guide you to make sure that whatever you're creating on your own is accurate for your wishes. There's also the trust mills out there. I'm not going to say who, but there are seminars that are conducted by trust lawyers, and they'll have 30 or 40 people. Well, we have 20 some people in this one, but they are out there to get you to sign up at the end of the session, and they're going to charge you $3,000-$4,000 to do the whole plan. But there's no customization and there's no time that you can spend reviewing the documents with these traveling salesman trust mills. So again, bare bones trust, really, you want to be careful about doing that. Be careful about using LegalZoom or Trust and Will or whatever the system that you're going to use to create your own trust, because you don't know what you don't know. And so you want to get with somebody who does, who can help guide you through this process. A fully funded trust is like a well-packed suitcase that you take on a trip, and you've really thought about it. You made your list and you included stuff that you may need. You may not need it, but you may need, and this includes everything. It's filled with things that you may not have anticipated, the fact that the money might be used to purchase a farm down the road, and there may be environmental concerns or other issues that come up. You want to have the ability to pass these assets on easily to the beneficiaries of the trust. So what does that mean? My mom was 92 when she passed away, and I was her trustee, and there were three siblings, myself and two brothers, and my nephews, who were my sister's kids. We were able to wind up the estate and distribute the trust according to her wishes in 3 months. I'm not kidding. And it can be done very quickly, depending on what the assets are and where they are, of course. But if they're in the trust, it makes it a lot easier. And the trustee, who's the trustee? It's you. You're the trustee of your trust. You make all decisions over assets in your trust. You have legal title. You control what happens with those assets. You can put assets in the trust at any time, take it out at any time. You don't have to ask anyone for permission. And when the time comes, if you become incapacitated or unable to manage your affairs, you're going to have successors in line who can step up and manage the affairs for you while you're still alive, but may not be able to manage it for yourself. And then after you're gone, you're going to have a detailed plan as to how the assets pass to your kids or your grandkids or your loved ones, siblings, cousins, friends, whoever. Charity, it all is covered under the trust. So it allows you to control your assets over the long term, and this allows you to plan for a lot of different situations. Did you know you can have a pet trust? So you can set aside funds in Virginia and DC and Maryland in a separate sub-trust within the trust. It's all part of the same document that makes sure that your beloved pets, I have 3 dogs, are taken care of if something happens to you. What happens if you die and your spouse wants to get remarried? What can you do and what shouldn't you do to take care of the spouse and not allow the spouse to distribute the assets to the new spouse or the new spouse's kids? Do you want to make charitable contributions? I have one client who just did a statement of faith that we attached to the trust, and it was very focused on their specific faith. You can change it easily, and then it also allows you to maximize the tax treatment. And who knows what's going to happen? Let me digress for a second. What is the tax treatment today? Everybody gets a lifetime exemption from the estate tax in the federal law of $13.61 million this year, and it's going up to $13.99 million next year, lifetime. So a married couple effectively next year can shelter $14 million. The law is scheduled to sunset at the end of 2025. Because the Republicans now control the presidency and probably the Congress, they may extend that sunset, and they may cause it to go into the future, but they cannot conceivably make it a permanent change in the law because there's too much revenue associated with these changes that they made back in 2018. They enacted laws that reduced income tax primarily for the wealthy, that would allow for 99.9% of the US population to avoid estate tax. If it sunsets, the estimates are about 75% of the US population would avoid estate tax. If it doesn't sunset, that 99.9% number will continue. But we want to make sure that we build in flexibility into your trust so that whatever the exemption is, so if the Democrats take over in 4 years or in 8 years, and they completely restore the estate tax exemptions at a lower level or increase the tax rates, we want to build flexibility into your documents so that they can morph as time changes. In addition to a trust, you have to have a will, which is known as a pour-over will. We don't want to use it if your kids are all over the age of 18, but if you have to use it, you establish a guardianship under the will, and it takes care of assets that you forgot to put into the trust. That means it still has to go through probate, but at least it gets to the trust and passes under the trust. In addition to the will and the revocable trust that you need powers of attorney over finances and healthcare. That will take care of things that are outside the trust, such as you have a safe deposit box. You didn't put it into the trust. The power of attorney allows the agent to move assets into the trust that you forgot to move and you became incapacitated. It allows the agent to settle litigation, to initiate lawsuits, to sign contracts, to enter into contracts that aren't covered under the trust. So it's linked up with the trust. And then, of course, healthcare decisions. A separate power of attorney or advanced medical directive is needed for healthcare. And that allows the agent over your healthcare to make decisions for you if you cannot make them for yourself. And a living will takes it one step further. It says if you're terminally ill and death is imminent, you authorize the withholding of life-prolonging procedures, but it might be morphed or changed based on your wishes. And we get into discussions as to what those changes might be. So what doesn't work? Doing nothing. What may not work? Signing simple will, owning property jointly, beneficiary designations, bare bones living trusts. What does work? A fully funded living trust that is customized for you. You don't want a trust mill to do your trust and tell you what you should do. They should be asking you questions about what you want to do, and then giving you examples of how it works. And again, it helps you make sure that the assets pass to who you want when you want them to. It also takes care of you during your lifetime. So you have access, a revocable trust can own anything. You can have a bank account, investment accounts, you can write checks out of it. That was the hardest part for elderly clients, is getting them used to having their assets in a revocable trust. But once they do it, it's seamless. It gives you total control. And again, it tells what happens if you become incapacitated or you pass. We want to protect your spouse. We want to protect your kids. We want to protect your adult children from themselves and from predators and creditors and the tax person. And we also want to make sure that we have done all that planning in the trust. And so all of these things can be accomplished in a revocable trust. It's a long document often, but it takes care of a lot of issues that you may not have thought about, or you may have thought about and you don't know how to handle it. So again, it avoids probate. Most importantly, if you've put the assets in the trust, you can use a beneficiary designation to have an IRA flow through the trust, and it can work very well depending on what you want it to do. And it does the same thing that a will does. It's often called a will substitute, but it does more. It avoids probate. It offers privacy. So there's no way that you have to file anything with a court. You save money doing that too. And most importantly, these trusts work in all 50 states and the District of Columbia. Depending on the state, you may need a joint trust if you're married, or a separate revocable trust. In community property states like Texas and California, we use joint trusts frequently, and we'll combine them with separate trusts, depending on the size of the estate and the types of assets that are owned. So this is a checklist of all the stuff that you want in your estate plan: a trust, a pour-over will, the healthcare power of attorney, also called the advanced medical directive, a power of attorney over finances or a durable power of attorney, a living will, which you should have, not if desired. I always encourage my clients to do it. You might even have an anatomical gift form, notarized funeral instructions in Virginia to tell whether or not you want to be cremated or buried, and where you want to be buried or where you want your remains to be placed, and then have an assignment for personal property, and then fund the trust with deeds and assignments for LLCs and corporate stock. If you need more info, Ann will tell you how to get in touch with us. So that is a brief but comprehensive presentation. And now it's time for questions, because I know that everybody's got questions.
All right. Thank you so much. Yay, now we can see a Teresa. Hello.
Look at that. Look at that. Everybody's here.
Okay.
All right. So how do you want to do it?
Before we get into the questions, I just have a clarifying question. When you were talking about the exemption going up to, let's round up 14 million next year,
Yep.
for married couples, that is double.
Yep.
Okay. I just wanted to make sure.
And in a married couple, unlike it was before 2011, the surviving spouse actually can roll over or port the unused exemption of the deceased spouse, but that's not always the best estate planning, depending on how big the estate is. So if you can use portability, you have to file an estate tax return on the death of the first spouse in order to qualify for using the unused exemption. And I just did one. We just filed one today for a client that needed to elect portability. And so they're porting over their exemption. That means they get to take the unused exemption, which in this case was 12.92 million because he passed in 2023, plus the surviving spouse's exemption, whatever it is when she passes. And that might be another 30 years from now. So we don't know.
Yeah.
Well, we want to make sure that we open it up to address your questions, all of our attendees here. So there is a Q&A option available to you where you can submit a question that we're more than happy to address during the call. And Wayne, we did receive some questions in preparation of our webinar today. So while we wait on some questions to come in from our live attendees, maybe we can start with some of those.
Sure.
So one of the big ones, and I think it's one of the ones that we get a lot from clients as well, is about how to own property. Should property be titled in the name of a revocable trust or some other form other than just an individual or joint ownership?
Okay, good question. Here's the answer that I would give. If you've got a married couple, the way it's typically titled is tenants by entirety in Virginia, which means husband and wife, or husband and husband, or wife and wife, okay, under current law. And so that is a very strong ownership structure. That means a creditor of one of the spouses can't get to the asset. So you'd say, well, why would I ever do anything different? Here's why. If one of the spouses becomes incapacitated, disabled, can't sign off on a refinancing or a sale of the property that is needed because you need the proceeds to support the incapacitated spouse, you'd have to go to court and enter into a conservatorship proceeding. And then you have to file accountings, and it's going to cost you 4 or 5 times what I'm going to suggest would cost. If you put the assets on the other hand, let's say it's a house. If you own a house as husband and wife, or husband and husband, or whatever, put it into the 2 revocable trusts or joint revocable trust. That asset protection that you get for husband and wife or spouses under Virginia law applies to the trusts. There's a statute in Virginia that says that. Same thing in DC and the same thing in Maryland. And then if there's an incapacity situation where one of the spouses is incapacitated, the other spouse, who is the successor trustee, automatically has the power to do whatever needs to be done. Refinance the property, sell it, lease it, whatever, without going to court. That in and of itself should tell at least married couples that they should always use a revocable trust to own their real estate. Second reason is if you've got a second piece of real estate in a county outside of Fairfax County or Loudoun County, somewhere else, or in another state, let's avoid ancillary probate. Let's title the property, even if it's in North Carolina, South Carolina, Florida, title it in your revocable trust. And by doing that, you avoid having to go through probate in the other jurisdictions, saving thousands of dollars and headache and delays. So hopefully that answers the question. Sometimes you may put an asset into a limited liability company for asset protection, but I typically reserve that for vacation homes that you want to keep in that family for generations, or rental property. And then if you have rental property, you have to be very careful about what jurisdiction it's in, because if you put it in an LLC, it might trigger recordation or transfer taxes, or it might increase the property tax assessment, and it will increase the insurance cost. So these are things you have to be aware of. But I have clients with 100 properties, and they have literally 100 LLCs that are owned under a holding company. And we help them with the titling of it and make sure that everything is there so that the LLC is then owned by your revocable trust, not by you individually. And again, the LLC interest would have to go through probate, and you'd have to file appraisals and do all this other stuff. Avoid it. Put it in the revocable trust. And if you have to go through a tax analysis where appraisals are necessary, so be it. But that's for the ultra wealthy, who I represent probably 300 different families that are in that category. But most people, like everyone on this call probably, are not quite in that category. And so we have, our assets are under the exemption. Don't have to worry about doing appraisals every time. So put it in the revocable trust. You don't have to file an inventory, which might require an appraisal to ascertain what the value is so that they can impose a probate tax in Virginia. Let's avoid that.
So one of the other questions we got, Wayne, I'm sure it's your favorite, is about cost. Some folks,
You get what you pay for.
Yeah. Some folks are, interested. They know that they need to do estate planning. So if you can just maybe share high level, and we understand it's based on complexity, et cetera, but high level understanding of what kind of a full estate plan costs typically.
Our firm is kind of in the middle to lower end of the cost for law firms in this area. And today you'll see estate planners. Some estate planners will charge you $2,000 to $2,500 to do a complete estate plan, but that's going to be a bare bones trust. There's no deeds that are going to be prepared to put into the asset into the trust. There's no advice on structuring a customized trust and all the other stuff that goes into it and reviewing the trust. So there's another law firm that I'll call a trust mill. I'm not going to say who they are. They hold seminars all around the DC metro area, and you can go attend one of these seminars for free, and they'll serve you some refreshments and things like that. And they'll charge you $3,000 to $4,000. Usually it's $4,000 to do the complete estate plan. There's very little customization that goes into it. So like I said, you get what you pay for. On the high end, it's $10,000 to $15,000. What we typically charge is between $5,000 and $7,000, depending on what has to be done. So if it's a blended family where we're putting together two families that have kids from different marriages, it's usually at the higher end. If it's a family that, has it's a married couple with kids, everybody's been together for 30, 40 years, 20, 30 years, everybody's comfortable. It's a little easier. So it militates towards the lower end of the cost. Our process is very detailed. We actually have a detailed handout that we hand to everybody on terms of our process and how we conduct it. And our fee also includes an annual update. So not all estate planners will do that any longer. If you go to see them, they charge you for it. We'll do an annual update. We'll sit down with you and your financial planner and go over the situation. What's the tax situation? What's your personal situation? What's your financial situation? And if changes are needed, then we'll figure out what the cost is going to be. But we usually work on a fixed fee. For advanced estate planning, it's much more expensive when you're talking about clients with in excess of the exemptions. And then the other thing is funding the trust. What does it cost to put assets in or direct assets to? And usually our fee will encompass some of the funding. But for example, if we have to do a deed, we charge a flat fee for that, plus whatever the recording fee is. And most estate planners do the same thing. So we're probably middle of the road to lower end. If you go to a DC based firm where the partners are charging $1,000 to $1,200 an hour, you're going to be paying hourly and you're going to be incurring a much higher bill. Whereas I think we try to stay fixed and do it very, very carefully.
Yeah, and I'll just mention that this is where it's really important for us as your advisors to know that you are updating your estate plan, because I know Teresa and I have seen multiple times, and I'm sure Wayne, you see this, where people go through the cost and the headache and the not great experience of doing your estate plan. It's not fun to talk about these things, let's just be honest. But they go through all of that and then they don't retitle assets. They don't change their beneficiaries. They don't update their bank accounts or, change the deed of their home. And it's like, why did you go through the cost and the pain when you now don't even have an estate plan? So this is where we really come in and also make sure that any changes that we need to affect for the accounts, we are making sure those get done. So that I just wanted to mention that's like
very important.
Tying the bow on the estate planning process is making sure all those changes occur.
We work very closely with our financial advisors that we work with, and we work with many, including Ann's firm, all across the DC area and across the country. So there was another question I saw come in from someone about the fact that they live in Massachusetts and they have an estate planner, or they may need an estate planner. The question is, what can we do for you? And so I'll tell you how we work with clients out of state. So we're licensed in Maryland, DC, and Virginia. And there's unauthorized practice of law statutes that prevent me from practicing law in Massachusetts. So there's two ways to handle it. With our higher net worth clients, we will work with clients in Florida and Texas, California, Massachusetts as well. We'll help design and draft the documents, but then we have an attorney on the ground that you retain to review our documents, update, upgrade them, and execute them with that attorney. And then we get copies sent back to us. So literally, we have clients in probably 40 states and the District of Columbia, but I cannot execute those documents in final without having somebody on the ground review it and approve it and consult with you on that, because that would be unauthorized practice of law. So in Massachusetts, we actually have people that we will refer to you depending on where you live. In all 50 states also, we're members of Wealth Council, which is a sort of a loose association of estate planners all across the country. And I usually look for people that have some experience and know what they're doing, because there are people out there that are members of Wealth Council that haven't been doing this very long, and you want to make sure that you're with somebody that has experience.
Yeah. We also received another question, and I know you mentioned in your process as well, Wayne, that your firm does an annual review of documents with your clients. But if there are clients who are working with other attorneys or got estate planning documents done years ago, how often do you recommend a review of wills and trusts?
I'll tell you, that's why we do it, have an annual review option. It's not something that's mandatory, and they don't have to pay us for it, but it just gives the client the opportunity to interface with us. And what we try to do is interface with the financial planners at the same time. So if a client calls us and says we want to update our stuff, we want to make sure that we know who their financial planner is. And there's one client on the list that I saw today who just came in for an update for us. And we want to make sure that we're talking with you about beneficiary designations and so on, so that they're taken care of, and that all of the assets are in trust or going to the trust if they should go to the trust. It's not always 100% of the time. So how often? It depends. Depends on how big the estate is, how complicated it is, how much the individual owns in terms of value of assets, how much life insurance there is, and make sure that you're keeping up to date with your financial planner at a minimum. So the financial planner is going to be meeting with you quarterly or semi-annually or annually, depending on who you are, and we just want to be part of that process so that nothing is suggested that either is incorrect or inappropriate, but also we don't want to suggest something that's inappropriate or incorrect. We want to work as a team, as a collaboration. So it could be every couple of years. We had a client come back in after 15 years just recently. We're grateful that they still think of us in that vein, but we also send out mailings and newsletters to keep in touch with our clients so that they know that we are still here doing stuff in the estate planning realm.
So there was a second part to that question too,
Mortgage?
in that they were told that they couldn't have a property in trust if there's a mortgage. So can you speak to that?
Oops. What's going on there? I'm not unlocking my iPad. The answer is that's not true. It used to be true probably all the way up until 2009, 2010. But if the trust is properly drafted, meaning that the property can be moved into trust, there's actually a federal law that requires the mortgage company or the bank to allow you to move your principal residence into the trust as long as the trust is properly drafted. And so when I say properly drafted, it allows for the trust to be liable for the mortgage. You're not going to avoid the liability by putting it into trust, unless you're trying to set up some type of asset protection trust, which is beyond the scope of our discussion today. So in a revocable trust, you should be able to move that property into the trust without any problem. And the lender may ask for an opinion from the attorney, which is usually a one-page boilerplate opinion saying that the trust is allowed to own the property and the trust is liable for the mortgage in the event that the mortgage holder dies, the mortgagee. So we want to make sure that the trust is properly drafted, but we've not had any problems in the last 10 years about any assets being owned in trust with mortgages or deeds of trust on them.
Well, on our call today, before we start wrapping up, and please feel free to submit more questions if things have come up, but we do have and have invited a lot of the next generation of our clients, their children, nieces and nephews who might be joining us today. So I want to make sure that we at least touch on maybe some considerations for estate management or trust management as the successor, or maybe even who that person should be, right? Who the successor should be, who the executor or administrator of estate should be, and what sort of things should they be aware of in stepping into that role?
That's a great question. Who should be a successor trustee of a trust? The initial inclination is, well, it's got to be my spouse. And then if my spouse is not living, it's going to be my kids. Well, what if the kids don't know how to manage their way out of a paper bag? What if the kids are not good with money? What if the kids have creditor problems? Okay, so this starts raising, okay, who can serve as a trustee? There are professional trustees out there, people who serve in that role. We do occasionally, but not when we're drafting the documents because there may be a conflict of interest. But in some cases, the client may want us to serve because we have experience in serving as trustees and in representing trustees. But beyond us and beyond attorneys and CPAs, there are corporate trustees. Depending on the size of the trust and the complexity of it, a corporate trustee may be a good choice. Corporate trustees don't have to manage the assets. You've got Ann and Atricia for that, right? The trustees don't have to manage the assets, but what they will help with is administration of the trust, making sure that tax returns are filed, making sure that if there's an accounting that has to be given to a beneficiary, not to a court, that it's done properly. And finally, making decisions over distributions to the family. But it really is a very personal issue. And so you could name an individual to serve with a corporate trustee. I wrote a book called The Successor Trustee Manual. It was published about 8 years ago, but it's still valid. The only thing that's changed are the exemptions under the tax law. And, we're happy to share that book with anybody. It's a short manual that basically says, here's what a successor trustee needs to know. Here's what they have to do after somebody dies. And here are good choices of successor trustees. But it really depends on each individual situation. And so I would say that's one of those customization things that comes up when we're dealing with planning for the next generation and beyond in constructing the trust. It's not always kids.
Right. So we did get another question submitted that is kind of in that same realm.
Okay.
How would you advise handling a property in a trust of a deceased parent that still has a mortgage in the parent's name, and you are the successor trustee once the mortgage is fully paid?
Once the mortgage is fully paid. If the mortgage is fully paid, then you can do whatever the trust says you can do. So again, I always say, well, what does the trust say? You've got to look at the trust instrument. There's no state law that governs what happens unless the trust is silent. So a well-drafted trust will tell you what happens next. If you are able to pay off the mortgage using other assets in the trust or selling the property subject to the mortgage, and then you pay off the mortgage in the sale and there's net proceeds left over, then what happens? The trust tells you what happens, should tell you exactly what to do if you're the trustee. And so you should be following the trust instrument. And if you can't read it or you don't understand it because it's written in legalese, get your lawyer who drafted the trust to advise you on how to interpret it. If the lawyer's not around because they've retired or you don't like the lawyer, go to somebody else that can help you administer the trust, understand what needs to be done. So usually an attorney who's well-versed in trusts and estate law will be able to tell you what to do next, depending on what state you're in too. Every state's got their own rules, but generally if it's in trust, you can do whatever the trust says you should do. And that is pay off the mortgage, great, or sell the property, pay off the mortgage, and then how do you distribute the proceeds? Are you supposed to hold it in trust for the beneficiaries? How long? What do you have to do after that? What kind of income tax filings do you have to do after that? Because everyone is going to have income tax filings if the trust stays in existence, just as an estate has to make income tax filings in a will, in the case of a will. So if the trust allows you to distribute the assets, distribute them, but you've got to read the trust. And if you don't do what the trust says and you violate the trust, you as the trustee can be personally liable for breach of fiduciary duty. So that's why you definitely want to, if you don't understand what the trust says, get somebody to tell you what it says so that you follow the trust terms.
So Wayne, you touched a little bit on blended families, but we also wanted to ask you, what are some of the issues that blended families should consider when they're thinking about their estate plan? How much time do we have? There's a lot.
I'll go as long as you want, but
we got 5 minutes. So
5 minutes.
I know
On a
there's a
blended family,
laundry list.
it really depends on how the two spouses who have kids from prior marriages want to treat the kids from prior marriages. I'll give you an example. I had a really complicated one come up the other day. Husband has trusts that were created for him by his mother and his grandmother, which have millions of dollars in it. Wife her husband passed away, and she inherited a bunch of assets by virtue of life insurance that was paid to her. Also millions, not a million, but a couple million or more. And the issue was, wife wants to make sure that the assets that came from their first marriage are segregated for the kids from the first marriage. Husband wants to do the same, or has to do the same, because he's bound by these trust documents. So what do? We have provisions in the trusts that relate to the kids from the prior marriage, and we've got provisions in the trusts that deal with maybe treating them all the same, or giving 2/3 to one group and 1/3 to another group. It all depends on what everybody wants to do. That's why it can be very complicated, and interpreting that and then putting it into writing is a challenge. And that's why it costs more for a lawyer to draft documents for people who are in blended families, simply because they haven't necessarily talked about all this stuff between them, and they have their own thoughts about assets that they may have brought into the marriage. Last point, do they have a prenuptial agreement that tells us what to do? And if they do, great. The prenuptial agreement will actually govern everything. Regardless of what you put in the trust, the prenuptial agreement will override even the trusts. So you want to draft the trust consistent with what the prenup says.
Got it.
Anything else? Any
All
other
right.
questions? I'm happy to
Last-
spend as much time as everybody wants to spend, but we've been on for about 45 minutes. So
yeah. Thank you for all the information. Last call. If there's any other questions, you can
it
drop
looks like there's
those
a couple
in
more
the-
popping in. It is not fully paid yet. I would like to obtain a copy of the successor trustee manual. How would I get that? And give the person who asked send them an email, and we'll send them a copy.
Okay. Yep. Sounds great. All right. Teresa, you want to wrap us?
Yes. Well, we want to thank you all so much for taking time to join us. And of course, a special thank you to Wayne Zell for all of the insight and information you have provided. Estate planning is always a popular, even though not a fun conversation to have with our clients. So thank you for that. This, as a reminder, will be recorded, or it has been recorded. So we will be able to provide a recording of the video to you probably by next week, that you can feel free to share with others and of course revisit. And then Ann and I are more than happy to connect those of you with Wayne if you are looking for estate planning services. So again, thank you so much. We appreciate it. And until the next time, have a wonderful Thanksgiving.
Yes.
Thank you all.
Thanksgiving. Thanks, Wayne.
Bye-bye.